everyone. Vanakkam, Assalamu alaikum, and good evening. Welcome to the fifth in our series of online discussions under the theme Bounce Back Sri Lanka, created and curated to bring you information, empirical insights, analysis, and in-depth knowledge on the topics that are really relevant and immediately impactful to you in crafting your business recovery on a sustainable upward trajectory as we move forward facing the challenges that not just COVID, but the universe brings us. Now, as you know, over the past 2 months, we've looked at identifying and discussing the foundational steps that need to be taken to pivot sustainably as we navigate these troubled waters. We had a national SWOT analysis. We spoke about agility and repurposing in your business model. We spoke about leadership in times of crisis. And last session, we switched over to discussing prevalent GeoSL policy, more specifically that related to import restrictions, how this affects Sri Lankan businesses, and what we could do to circumvent or mitigate the challenges sustainably. Reminding you, as always, all these discussions, as well as the recordings of our previous series, the AmCham Knowledge Hub series, are available on our YouTube channel, AmCham Sri Lanka, and I encourage you to have a watch or listen in the background for some invaluable insights and tips. Today, in the fifth of this Bounce Back Sri Lanka series, we'll take a look at what we're calling business integrity in the face of adversity. Simply put, contracts and compliance. How do you meet contractual obligations in a world where nothing is the same as when you made those contractual obligations? When the supply chain is on its head, what is your obligation and liability as a director? How do you manage expectation and sustain consumer or customer loyalty in spite of these challenges? And also, what opportunities does this new business environment bring from a perspective of private equity funding, joint ventures, and what about in terms of mergers and acquisitions? What do you need to know, either as a big fish or even as a little fish that might get swallowed up, which may not be a bad thing right now? So sharing with us their invaluable time, knowledge, and insights today, we have a very distinguished panel of experts. Let me begin by introducing our panel chair and moderator, President's Counsel, Chandaka Jayasundara. Mr. Jayasundara has a practice spanning almost 30 years, specializing in commercial law with special emphasis on maritime law, multimodal transport law, international trade law, company law, intellectual property law, and arbitration in the District Court, Commercial High Court, and the Admiralty Court. He is also a lecturer at the Sri Lanka Law College and a visiting lecturer at multiple institutions, including the University of Colombo and the Institute of Commercial Law and Practice in Colombo. President's Counsel Kuvera de Souza, also a veteran of almost 30 years, specializes in the areas of civil and commercial litigation, intellectual property law, international trade law, investment law, international arbitration, insurance law, and maritime security law. Of course, Mr. De Silva has spearheaded many IPOs, providing legal opinion and strategic and value-adding advisory services on diverse commercial and corporate transactions, and he has also served as the chairman or director on the boards of many companies, both listed and unlisted, and further served on board-appointed audit, legal, risk management, remuneration, and executive credit committees of leading corporates. He serves as a member of the committee appointed to examine and address the shortcomings of the Civil Procedure Code Amendment Act No. 8 of 2017. And of course, a little birdie whispered that in fact Mr. De Souza has declared his intention to stand for president at the forthcoming Bar Association election. So we wish you all the very best from all of us here at AmCham, and of course all of us joining us on this discussion. Ms. Rajitha Jayasuriya is Group Director Legal, Mass Holdings, having established the organization's legal function in 2004. She heads the overall legal operation of MAS. Rajitha provides strategic advice to the shareholders, the board, and the executive teams of the apparel industry leader, negotiating and managing cross-border ventures across new business verticals, including innovation, startup acquisitions, brand and IT solutions. She draws from a 2-decade-long career in enterprise-driven legal functions spanning corporate governance, intellectual property management, local and cross-border acquisitions and divestitures, contracts, banking finance, compliance, and global structuring. Rajitha is an attorney at law of the Supreme Court of Sri Lanka and holds a Master of Law from Monash University, Melbourne. She is also an alumnus of the prestigious Stanford University Business School and the National University Singapore Business School. And as a Bishopian myself, I'd be amiss not to mention that she's a past pupil and a distinguished one at that of Bishop's College. Rajitha, I believe congratulations are also in order as a new mum. So thank you for taking the time to be with us here despite all those challenges. Last but certainly not least, Mr. Krishna Ramachandra. Mr. Ramachandra is Managing Director of Duane Morrison Selvam LLP and Chairman and Managing Director of Selvam LLC. Born in Sri Lanka and domiciled in Singapore, Krishna graduated from Christ College, Cambridge with an LLM in corporate finance on a Freshfields scholarship. He articled and qualified with Freshfields in London prior to relocating to Singapore with Clifford Chance and subsequently joined Selvam LLC. Krishna is an advocate and solicitor of the Supreme Court of Singapore and a solicitor of England and Wales. He previously sat on the Singapore Law Society's Corporate Practice Committee for Mergers and Acquisitions and Insolvency, Corporate Commercial Matters and Listing Matters. He speaks regularly on a wide range of topics relating to M&A, corporate governance, listings, fundraising, and establishment of an Asian presence at venues around the world. His practice includes M&A and capital markets, investment funds, private equity, financial technology, sports and telecommunications, media, technology. Krishna also has significant experience in Myanmar, Indonesia, Malaysia, Taiwan, and Korea, bringing to us all this extensive experience and knowledge in this conversation. His extensive experience, of course, in mergers and acquisitions and takeovers, private equity participation, and exit strategies has led to his being regularly cited by the reputable directories as a leading lawyer, and he is listed as one of Singapore's top 100 lawyers by the 2019 Asia Business Law Journal edition, with Asia Law Profile 2020 recently naming Krishna as a distinguished practitioner in the corporate and M&A practice area. On this end of the table is little old me. I'm Rai Raymond, General Manager ED of the American Chamber of Commerce in Sri Lanka, creator and facilitator of this series. Mr. Jayasundra, let me hand over to you.
Thank you, Rai, and good afternoon, and welcome to this webinar on contracts and compliance, business integrity in the face of adversity. When this topic was given to us, I spoke to Kuera and we were wondering what exactly was required from us, because it covers a fairly vast area of not only the law but actually of some philosophical thoughts about what integrity is in the business community, and how do you act with integrity at times of adversity. As we all know, integrity can be both personal as well as corporate. Integrity basically would mean that you do the right thing for the right reasons, and that you don't cut corners, you don't break the law, and as we lawyers say, you can bend the law but you can never break the law. So basically integrity means that you have to do the right thing. Doing the right thing, especially in a commercial sense, sometimes makes things very, very hard to do. It would take more time, more effort by all your stakeholders within your companies to actually do something with integrity. But in the long term, integrity is the bedrock on which the reputation of your companies, of your professional practices, of your professional life would depend on is integrity, which is basically honesty, and always, whatever the reasons, whatever the pressures, whatever the adversity, that you do always do the right thing, because in the long term, integrity is what will keep you going. Personal life, what you call character, a human being, is similar and comes from integrity. And in corporate life also, and in the corporate sphere, it's also very important that you act with integrity. Now, in respect of corporate integrity, you have two aspects of corporate integrity. That is, one is the integrity of the entirety of the corporate or the structure or the establishment, and then as against that you have the integrity of the individual employees of the company. So in adversity, as they say, adversity normally brings either the best in you or the worst in you. So what we require, or what the world requires is, and what is accepted, is that the true character of a person or the true nature of a corporate comes out only in adversity. Because when there is adversity, it's very, very difficult. You tend to, because of the adversity, because of the pressure that is there, you tend to naturally cut corners, but that is that is the very thing that you need to act against at the time of adversity. Then again, with regard to the employees and the other stakeholders of a company during an adverse situation, especially when the situation has arisen that most of your employees will be working from home, then the controls and the natural restrictions that are available in a more office physical environment will be lessened due to the fact that you are now staying at home, and as most of us maybe, you would be having meetings with your top quite formal but your bottom quite informal, right? So that would be the institution, because when you do go into a digital environment and where your dealings with other people are digital, that basic human touch and the human connection is not there. That is more so when it comes to contractual diligence or contractual integrity, because when you are not face to face with a person, especially in a very Asian background that we have, the chances of things not happening honestly is very high. Number two, it is also a situation that your employees, because they are offsite, the chances of them also acting in a manner that is against the policies and the philosophy of company is also very high. And the other issue is that if you look at in an adverse situation, in adversity, there are enough and more people who would like to who would like to prosper using that adversity. So that is one aspect. So in adversity, you need to look after your whole entire organization. You need to look after your employees. And number three, you should be, especially in a digital environment, you should be mindful and be protected against any attack on your integrity. Having said that, as an introductory manner, I will, because we will be at a later stage having another small small discussion with regard to each point, and I would at that point would like to speak a few words on the obligations of company directors in adversity, financial adversity. But having said that, I don't want to take too much time on it. I would like to start by inviting Krishna to speak, as most of our participants are from Sri Lanka. Would like to have, if you can briefly tell us the situation in the corporate situation in Singapore, and also what sort of, with specific regard to integrity in contracts and integrity in investment, how you would approach that problem. And over to you, Krishna.
Thank you, Chandika. And thank you, Rai, for a very great introduction. It's a pleasure to be here tonight. It's already the evening in Singapore. I do miss Sri Lanka, and I hope you guys are all doing very well. It's an interesting question. It's actually very wide, because it's integrity is something that's it's pervasive. It exists whether in a crisis or in a non-crisis situation. But as Chandika mentioned, it comes to the fore in these circumstances. Singapore has had a unique experience. It's, as you know, it's reputed for being a very well-organized, well-oiled country. But perhaps what has really come to the fore was its ability to tap on its resources. And, quite frankly, if it hadn't been for its ability to tap on close to about 100 billion Singapore dollars, close to about 70 billion US dollars, it would have forced the situation where we now see and we experience in a lot of other jurisdictions, where jobs have not been guaranteed for some individuals. There's not been a moratorium introduced to prevent landlords from chucking out some of their commercial tenants, where we have also had the courts to impose a moratorium on actions being taken against people who are not serviced their debt. So integrity does play a part, because you have also got situations where people might abuse the current circumstances to avoid pre-existing debts and obligations which they could not have paid. But that all aside, one observation that I have, certainly from the Singapore's experience, is it has forced the digital narrative onto us a lot quicker than many people had expected. And as a result, organizations have just been forced to adopt even right now we are all doing Zoom, and I can count on the fingers on my hands, the number of times I used Zoom last year, whereas it is now very commonplace, and even my mom uses Zoom, so that's saying something, and I think it's a good thing. So there are a lot of good things that have come about from this technology, whether it's Zoom or WebEx or whatever else you use, because integrity does come in on the basis that if you look at some of the activities, whether you are a student trying to take on an examination paper and you're doing it over Zoom, there are you can get creative over ways to perform in that exam, or you can actually be subscribing to what I call a commons protocol, which has existed for the longest time. That protocol which taps on basic human need and a requirement to just observe what's right, to do the right thing. It emanated from as far back as when people discovered amazing fish from a lake, right? And everyone started going and fishing from it. But after a while, overfishing happened, and then a protocol developed, and there were no laws to actually govern the behavior of that community, but it was just an understanding. And so I think we all have anecdotes of good examples and bad examples of behavior, but I like to think that it has also brought to the fore the commons protocol thinking that had been lost on a lot of us, because we have been over reliant on the state and various agencies to regulate our behavior. So it's in a way, in a very perverse way, it has humanized us in how we interact with each other. And for most part of it, I'm proud to say that what I've witnessed, whether amongst us practitioners or even outside of our field, is a good level of take up in the subscription of the Commons Protocol and in supporting each other. The government has been very supportive, and I mentioned earlier the digital narrative being put forward. So what the Singapore government has done is they've recognized that they need to step up and ensure that when the reskilling happens because of this digital revolution, there is an impetus to support either the mid-level executives or workers, and to allow for them to reskill in the digital sphere. So a lot of the programs and the grants that are currently being afforded by the government are geared towards, quite frankly, a program that's just been brought forward. COVID just brought forward these programs. So, and I've been focusing a lot on digitalization of ecosystems and economies in the last 3 years, and I've done quite a significant number of projects in that front. And it's been hard to push across that narrative. And so in a perverse way, I'm also quite happy that that narrative is now being pushed forward, because it was otherwise going to be a very insidious way of having a lot of people become dispensable and having their jobs taken away from them before they know it. And so in this way, everyone is now focused on this whole digital narrative. The other couple of things that Chandrika, that I wanted to mention about the integrity issue is, we have seen a huge push by corporates around the world in adopting ESG as a fundamental policy in how they either engage with a counterpart, or certainly from a private equity standpoint, in whether they make an investment dependent on portfolio companies that have an ESG policy, which is basically an emphasis on the how that respective company looks at the environment, looks at social issues, and looks at governance. It is not quite CSR. It's actually a whole jurisprudence in itself, and there are even indices around the world that measure how well behaved and a company is holistically on the intangibles. And integrity has actually crept in through the ESG in the last couple of years. So it's interesting to see how companies will now look at ESG as being a must-have as opposed to a nice-to-have in the past. So, not wanting to hog the limelight and the mic, I'll hand it over back to you, so the other speakers can weigh in.
Thank you, Krishna. I would now like to move on to quagmire, and specifically with regard to since we are looking at contracts specifically, and integrity and management of contract, because contract management is integrity is very important to contract management, because if you don't act with integrity and honesty with your partners in terms of contract, then it's very difficult to figure out how you are going to act ethically or with some integrity when you're dealing with outsiders. But specifically speaking of contracts and the provisions of contractual provisions in times of adversity, quagmire, how does an organization or a party to a contract deal with a situation where it would be almost impossible to carry out your obligations in terms of the contract for reasons that are completely outside our control? In such a situation, in law, there are provisions which deal with that. I would like to request you to make some comments on contractual provisions where parties to contracts can actually work within the provisions and within the four corners of the contracts and the law, so that you still continue to act with integrity and keep up your side of the contract without breaching a contract.
Thank you, Chandaka. Let me first thank the American Chamber of Commerce in Sri Lanka and Rai on behalf of the American Chamber of Commerce for affording me this opportunity. And I think, thank you, Chandaka, it's a very timely topic and subject that have been allocated to me by you to speak. I think I prepared a slide presentation. I think it's important that in the first instance that we understand the fundamentals coming to a question, how a contract would work during in the face of adversity. So in that context, I will also run through my slide within the given time, so that I can give a better understanding to the viewers of how a contract would perform, performance when it comes to performance, how that would operate. Rai, hello.
Can you see the screen now?
Yes, I could see the screen. So going to slide number 2. Yeah, performance of a contract during a global crisis. Now, this is in the face of adversity we are talking about. So I have basically outlined how a contract could perform, or the performance of obligations under a contract how it can be hindered in the when you are faced with a global crisis in the face of adversity. So I set out that business and persons all over the world are skeptical when entering into new contracts for fear that they may be unable to enforce the contract and or underperform the obligations under the contract. So parties are also, if parties have already entered into agreements, and if parties are left with no redress, then when such agreements are dishonored And the fear and skepticism is one of the biggest hindrances to economic recovery and growth following any national law or global crisis. Going to the other slide, I just tried to outline. Now, a relief available to a contracting party, although the remedies available, although the economic fallout following a global crisis itself, the relief available to a contract party depends mainly on the law governing the contract. So it's very important and necessary in the first instance to understand what law governs the contract that you are talking about or you want to enforce, or when you have to understand your obligations. So most international agreements will specify the law governing the agreements and may even make provision for alternate dispute resolution in the events of its terms are not honored. So the law on contracts in Sri Lanka is generally governed by the English law and also by the Roman Dutch law. So although the English law in this area has changed over time, there are fundamental differences in the approach to impossibility of performance of contracts between Roman English law and Roman Dutch law. I think that is where we are today, because we are talking about a performance. We are in a situation where performance of contracts in the adversity or in the COVID-19 situation that the parties are faced with. So the consequences of failure of performance, is it due to impossibility, will depend substantially and if not wholly on the applicable law. So going to the next slide, contract law in Sri Lanka, English law versus Roman Dutch law. So the Roman Dutch law and the English law has, even two different approaches, but of course there are similarities which I will try to discuss. Incorporates in Roman Dutch law, it incorporates an implied condition into a contract that performance is expected only if performance is possible, unless the parties have contracted otherwise. So covers situations where performance is due to force majeure, supervening impossibility operates as discharge unless otherwise agreed. So the next slide, Justice CGB says, unless it can be shown that either English law, statute law, or one of the systems of personal law governs the matter at hand, the law to be applied in matters of contracts would be the Roman Dutch law. That is as far as law is concerned. Then the next slide, I tried to explain and outline what constitutes a supervening impossibility. When the subject matter of the contract is destroyed, when the state of things that was the foundation of the contract has ceased to exist, when performance becomes legally impossible. These are the general situations which I tried to set out to give a basic understanding. Now, I've also discussed some case laws, which I don't think is it's there in the slide, but I don't think it's really required to go in. Then the next slide, there are limits to this doctrine, where the force majeure must render the performance of the contract impossible, simply inconvenient, or more expensive. So not inconvenient or more expensive. So this is a very fundamental thing that one needs to understand, because the performance has to be the principle. This principle does not extend to situations that merely makes performance difficult or inconvenient. It has to be simply impossible. So in that context, I decided also discuss the case here, Sri Lankan case, which is relevant in this context. Then the next slide. The English law, where absolute duty of performance have come into play, if parties have this absolute liability principle, there is this famous English case, which I've cited here, where a party by his own contract creates a duty or a charge upon himself, he is bound to make it good, notwithstanding any accident or inevitable necessity, because he might have provided against it by his contract. So that is something very important that one needs to remember. So the next slide. The English law recognizes the doctrine of frustration as a method of discharge of contract. So I have also cited a case here where frustration occurs whenever the law recognizes that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render a thing radically different from that which was undertaken by the contract. It was not this that I promised to do. So next slide. Where said situations where frustration has been successfully pleaded. I've cited some cases, and I've discussed this principle in the light of these cases, which has been cited in this slide. And if you go on right to the next slide, limitations. There are also certain limitations on the doctrine of frustration. If the frustrating event has been foreseen and provided for in the contract, that is something that needs to be considered. Now, there is this case that I have cited here as well. And in the commercial arena, force majeure and similar clauses may well replace the common law and statutory rules on frustration. The alleged frustrating accident has been self-induced by one of the parties to the contract. Now, all these principles have been illustrated and dealt in details in cases. There are cases that has dealt with these principles. And also the supervening event must have made the contract impossible, illegal or radically different. It is not sufficient that the performance of the contract has simply become more difficult or expensive. Part of the contracts can, if part of the contract can still be performed, then some of the purposes of the contracts can still be fulfilled. Then if you go to the next slide, consequences of frustration of a contract is discharge, money payable or goods deliverable cease to be payable or deliverable, money already paid before the frustrating event can be recovered, subject to the other party's right to deduct that amount, a sum for the expenditure incurred in performing the contract into the point of frustration. Then now we come to in the next slide, very important concept of the force majeure, where the definition of force majeure is constantly changing. If you go to the next slide, force majeure clause is a provision which, when incorporated into a contract, entitles the party to terminate or temporarily suspend it. All are part of the contract upon the occurrence of some triggering force majeure event. A force majeure clause will generally specify a list of triggering events and a catch-all item such as any other act of God. A force majeure clause may be drafted narrowly, limited to a specialized list of force majeure events or widely open to interpretation. If drafted widely, a party may invoke the force majeure clause in an event beyond their control, renders contract impossible or impracticable. Now, in today's context, it's important to keep in mind, if performance has become an impossibility, if one is to take up the position that you are discharged from liability of performance, one needs to carefully examine the force majeure clause. So if one is to enter into a contract in the aftermath of the COVID-19, I think one needs to take into consideration the ground realities, whether the COVID-19, when it became foreseeable and things like that, because it's important that if you are to rely on a force majeure clause, those matters will have to be adequately dealt in a contract. So next slide, the next slide. Can the COVID-19 pandemic trigger a force majeure clause? I think this is very important in today's context. Where a contract contains a force majeure clause, a party can seek to rely on it by arguing that COVID-19 pandemic is a force majeure event in the following situations. So where a pandemic disease is specified as a force majeure event, where certain consequences of the COVID-19 pandemic, such as trade embargoes, lockdowns, curfew, national emergency, closure of airports and harbors, constitute a force majeure event. By including a force majeure clause, parties can also decide what remedies are available to them in the event of such cases triggered. Parties can also decide to what extent the obligations under the contract will be discharged or suspended. So the next slide. So viable alternatives. I mean, it's important to remember that in the current crisis conditions, both the government and the business sector has stressed the need for continuity of business and relationships wherever it's possible. So this thinking also applies in exercising the force majeure. Working through possible consequences of a decision is critical. For example, what might be the status of your business relationship with your counterpart post force majeure. So is there a possibility of brand damage if you are perceived to exercise force majeure unfairly? So in the light of this, I think it's the renegotiations or extensions may seem to be a better option than invoking a force majeure clause or claiming frustration. So that's what I have tried to outline in this slide. And if you go to those are the viable alternatives. I think, and the law, basically I've tried to deal in the slide presentation. So when it comes to the question and answer session, I think we can deal with practical examples. Thank you, Chandra.
Thank you, Kuera. And now we will go to Rajita, who has enough experience in managing a very large corporate entity, and especially in one of the areas that has been severely affected due to the pandemic, as business as well as the amount of employment or the employees that MAS has definitely impacted not only on the business factors but also on the employee factor. But keeping that aside, I would like to ask you what, like, in a situation of adversity, what are the steps or what are the cautionary steps that you can take, especially when you are looking at with legal compliance, because in adversity sometimes it's very, very difficult to keep to some of the very strict regulatory dictates that have been set out by the regulators in a situation where there is not a pandemic in existence. So how do you approach the situation of legal compliance on the one hand, and also what are the steps that you can take if you are looking at investment, M&As, or specifically financial aspects and financial diligence when you are doing investments? I would like to ask Krishna also that part of it later on, but specifically for Rajita, specifically with regard to financial and reputational diligence and steps that the company organization can take with regard to legal compliance or regulatory compliance in a situation such as that we are facing today. Rajita.
Thank you, Chandika, and thank you, AmCham and Rai, for giving me this opportunity to be a part of this panel, and for the very generous introduction, Rai. Thank you for that, and it's a pleasure to be here. So Chandika, you raised a really good point, and I think it's something that's foremost in the minds of most corporates today. The pandemic is not something that was ever envisioned in our lifetime, and I think not many contracts or investment climates sort of provide for how we should react and respond in this environment. There are multiple constraints when entering into contractual arrangements and investments in these global conditions because of the economic conditions and the constraints that have been created by the pandemic, which then heavily impact on the investment climate, obviously. So all of this brings into light when you're doing cross-border transactions or M&A, or you're contemplating new investments, the importance of diligence. When you talk about legal compliance, diligence, financial feasibilities, all of this become very critical to a business or a corporate. And when you look at in any diligence exercise, we would look at from now with GDPR, the compliance with respect to global compliance on data protection would be something that we would look at very critically. And then, of course, in addition to the financial, environmental, people diligence, the key man policy that any organization has in this climate. How do you retain people who is important to an organization? What policies and contracts are in place to make sure that those key people are retained in a business once you have invested into that business? all those would have to be looked at very carefully, obviously. So diligence becomes a very critical exercise in this present investment climate, obviously. It's always very important, but I think there is like a double click on that now, considering the financial constraints that people are facing, because we are seeing global companies that are Fortune 500 companies, especially in the apparel sector, crumbling. They are all declaring bankruptcy. They cannot hold their employees any longer. People are being let go of. Businesses are shutting down, and the corporates and companies that we perceived as having great and immense financial strength no longer seem to be able to sustain themselves. So your financial diligence and your reputational diligence becomes really critical in this environment as well. $1 million deals are being frustrated, deals that have been entered into pre-COVID, post-COVID. Investors are walking away. We saw a similar situation with the limited brands investment, where there was a selling off of Victoria's Secret to an investment bank, but that contract was frustrated and it was overturned, and the investors walked away because they invoked a force majeure clause that said that the investment climate that existed at the time that they made the investment no longer existed, and that their investment was no longer at the same value that it was at pre-COVID. So diligence becomes really critical, and the integrity of organizations becomes really critical, and going really deep in becomes very important. And catch-all phrases to something that Quera also sort of mentioned. In a force majeure clause, we have a very broad catch-all phrase that says an act of God. No one sort of perceived that an act of God would not sort of also encompass a pandemic. We have faced situations where we've had suppliers, or there have been contractual obligations that parties have entered into that they would want to walk away from, that they would try to enforce a force majeure clause and say the contract is frustrated. And in situations where you're looking at, say, a cross-border investment or an investment into a jurisdiction like the United States, where there are federal laws and state laws. So state laws would interpret a force majeure clause quite differently to the way the federal laws would interpret it. So the interpretation of these provisions also become really critical. How you have drafted and crafted these clauses, whether you are investing in or trying to get out of an investment, becomes really critical as well. Because most jurisdictions, most interpretations have sort of confirmed that an act of God does not include a pandemic. So even though you have a force majeure clause, you don't have a get out of jail free card just because you have a force majeure clause in your contract. You would have to be very careful in your drafting and your crafting of your contractual provisions to ensure that now what was before perceived as a standard boilerplate clause is now extended to encompass situations of a pandemic as well. You would have floods, you would have lockouts, you would have so many other situations that you would list out as a force majeure, but not many of us would have listed a pandemic in a force majeure clause. So now it becomes important to us as lawyers to ensure that when we're looking after our company's interest or our client's interest, that we are giving due consideration and importance to the drafting of these clauses to make sure that our companies and our clients are protected. So the environment that we are sort of operating in was an unforeseen environment. It's not an environment that any of us were prepared to sort of operate in. But having said that, seeing the financial collapse that has occurred across the globe, it becomes very important that any investment in or out is looked at very critically, and then there's double clicking, especially on financial diligence, reputational governance, the environmental aspects of the environmental diligence of the company's performance, their governance, and of course the key man policies like I touched on before. And where companies are unable to sort of enforce those force majeure provisions or the contractual provisions for their protection, then of course they would have to look to the courts to ensure that their rights are protected. So that's not a very beneficial position. So it's really good to make sure that your diligence is very sound and effective, and we draft carefully as much as possible going forward, because these conditions have proved that large corporates, even though they are large, are no longer sound investments if you're investing in or partners that you can sort of rely on because of the pandemic conditions. I'm going to stop at that because there's a lot that has been talked about right now, but I would really like to understand from the audience also if they have specific questions from a corporate law angle that I would be happy to answer those questions.
Thank you, Rajita. Since we have more or less, because we were supposed to discuss points that have arisen out of each other's individual introductory comments, would anybody like to volunteer to comment on what?
Chandra, can I come and comment? I think Rajita, thank you very much. I think you also stated the importance of the force majeure clause, because whether COVID-19 really comes within a force majeure clause, I think that's something very, very important. I think there are also, if you are to discharge yourself, if one is to discharge yourself from performance and its obligations, I think there are alternatives to the force majeure clause. So alternatives would be doctrine of frustration or supervening impossibility. And that is something very, very important. And also we have the United Nations Convention on Contracts. Now Article 79 of the Convention, United Nations Conventions on Contracts for International Trade, basically excuses non-performance if it is from an unforeseeable impediment beyond a party's control. So that is something. And also material adverse changes, adverse effects in contracts, if that has been provided not directly by force majeure, but in some form, in some other clause. So as Rajita said, it's very, very important that in drafting and crafting these agreements, that I think this is something that has to be really looked at in today's context. And proper legal advice, I think it would be good for lawyers. I think most of the corporates would be basically seeking expert advice on this.
Thank you. Yes, Krishna.
Sorry, I was just going to add that not to belabor a point on the force majeure, but the universe exists also beyond the dispute resolution sphere. And what I mean is, we're looking at a sphere where corporate transactions still go on as per normal, because most corporate transactions haven't got to the realm of dispute resolution. And just to touch upon a few things that, just from a corporate governance standpoint, some of the typical issues that have arisen and that we have been advising on, as well as, how well should the board be kept informed and, in satisfying its own fiduciary duties, because both as a matter of oversight and in the context of all board actions, because it's been strange times, it's been unique times, and sometimes the board, particularly given that they are not, and some of them are external and non-executive, for them to be kept informed and kept abreast of what's happening is going to be key. So that's just one example, even if it means, what from a corporate governance perspective, I touched upon it earlier about ESG, but what are the best practices for business continuity and the crisis management procedures? Because if you look at, from a corporate governance perspective, these are super essential. And especially if you're a listed company, and to have all of these things in place, does the board have in plan, in case one of the directors, one or more of the directors, contracts COVID, what happens, and can the board simply increase its size to appoint other persons, has due diligence been done on that? So actually, from just putting aside force majeure for a moment, actually the entire universe of integrity actually traverses many, many aspects of the type of disclosure, the type of variations that from a corporate sphere we are looking upon. I mean, certainly, in my experience from working with some of the fund managers and private equity investors, they are looking at a whole host of things that that go into particularly on the disclosure perspective, because when they are assessing a company's financial might, it is a case of really having it compared against pro forma accounts. And when you're trying to now do pro forma accounts, do you just use the first 3 months of this year? Do you use the next 6 months? And would a pro forma set of accounts actually need to forecast what the next 6 months is going to be, pre-vaccine and post-vaccine? So there are all of these really small permutations that are actually at play, just from a discussion point, nothing to do with force majeure, but having an impact on all the legal considerations that any typical corporate entity would experience. I just wanted to put it out there as well. I mean, not to take any thunder out of yourself and Kubera, but that's we are seeing as much as we are seeing disputes around force majeure, we are also advising a lot of clients on how they're better equipped to navigate the corporate ecosystem.
Thank you, Krishna. So, would it be like the due diligence and everything has now become much more complex than what it was earlier? Is that and that you will have to be looking at matters that were not thought to be very important 6 months ago?
Yeah, absolutely. Because and it's more of a self-disclosure perspective. Because if you think about it, something as Jasita mentioned it earlier, something as simple as looking at GDPR and what are the employees' rights in terms of having their temperature taken, in terms of whether they have to disclose even more details about their health conditions, right? I mean, I'm simplifying it, but if you like, it's intersposed with regulations which ordinarily would not have applied, but now we are seeing that application. So imagine if you are a private equity fund looking to invest in a company that has got a significant workforce. What will keep them up at night would literally be, what are the labor issues that may arise and which are boiling and not necessarily have crystallized yet, but would certainly be an issue for terminations, for redundancy packages, and particularly when there's a restructuring involved post-acquisition. So these are major considerations, and it's something which I noticed that people are building in a lot more indemnities, more so now than they did in the past, and are happy to start negotiating up front with actually on the indemnities rather than which typically happens towards the end of the courtship, if you like. So these days they are looking at putting up front the types of indemnities they would require from the other side, and to the extent that the other side are able to provide it, to get the appropriate reps and warranty insurance as well.
Rajita, you have anything to contribute on that?
Yeah, absolutely. I really valid points that Krishna brings out, and just in terms of diligence, another aspect that was very key that I just sort of missed out on when you were talking about all the other aspects of business continuity, Krishna, was also the recent focus on cybersecurity. Because with all the ransomware and phishing attacks on organizations across the globe, this has also become a critical area of diligence that corporates have had to go into, where previously we would not have spent that much of time diligencing a company's cybersecurity policies. But now this has become really critical because it goes towards the business continuity of the organization in terms of how the integrity of the policies around cybersecurity have been crafted by that organization. Because everybody's information, including the organization's information, the employees' information, your customers' information, all your financials, everything is on your systems. And if you are then subject to a ransomware attack, that makes you very vulnerable and not very attractive in terms of an acquisition point of view. So cybersecurity is another very key and critical area that has to be looked at in terms of diligence in this environment.
Yeah, no, totally. I agree with you, Jasita. And we were joking about it earlier before the session, but I think a lot of companies have been caught with their pants down because they were not digitally connected or digitally prepared for their ecosystems to operate online. And this is something which is a big issue actually, and a lot of companies are now fast forwarding and accelerating their CS programs and whatnot.
Rai, would you like to start the questions and answer session now?
Sure, Chandaka, thank you. Actually, we do have a couple of interesting questions. One of them, I think, is directed at Krishna, because you're the one who'd be able to answer this. It says, we've noted that Singapore laws have introduced a freezing period during the lockdown where contracts do not get frustrated. What's the present situation of such transactions? What about the losses incurred despite such freezing period? And overall, what are your comments on this? Including, would this be something that makes sense for Sri Lanka to look at as well?
Yeah, I think that's a great question. By the way, we need to look at the genesis for that legislation. We had a legislation which imposed a moratorium on. Actually, the courts were just not functioning. The courts were not functioning basically to allow for only very essential matters to be heard. And alongside that, we had a moratorium on debts, that mostly on debt. And the frustration of contracts, as you know, you've got, as Vera and Chandaka had mentioned earlier, you've got the contractual provisions that would afford you the benefits, and then you've got the tortious jurisprudence as well, whether it's frustration or an impossibility. The courts have, we're actually working on a few construction and tourism related matters. Actually, interesting point and sidebar, if I may, Chandaka, when we talk about integrity, I think if all legal practitioners can even exercise that level of integrity in terms of how they interpret the contracts themselves, and how they know that instead of bending it, just to be pretty straight with the laws and their interpretation of force majeure, frustration, or what have you, that will help a lot. So, we even as practitioners have a major part to play in terms of how we propagate integrity in business rulings, because the client comes to us to find out if they can, whether they can either pull a fast one or they can try their luck. But it takes a lot of courage for us as practitioners to just put them straight and tell them that this is a period where you shouldn't be engaging in such long shots. But back to the point, the genesis for why Singapore introduced that was because, as you know, globally it was in versus what happened in previous financial crisis, if you like. You had perhaps one or two jurisdictions, or perhaps one or two continents that would have hit the wall. But in this instance, you had literally the entire world hitting the wall, and so there was a collective suffering. And because of this collective suffering, the only way that was feasible for the government to actually allow for business to actually continue post-crisis was really to have a moratorium and a stop order. Now, there has been no pronouncements as to how they would interpret particular factual scenarios in terms of the performance of contracts, and so that's still going to be governed by the traditional court approach to what has happened in the past. So we're not reinventing the wheel. Certainly, as Kuvera had mentioned, there is COVID-19 in this overlay, but COVID-19 in itself is, if you like, it's not a new phenomenon, because it's a pandemic, and so so long as you have got those features, whether it's been crafted into the contract or whether you're relying on a cautious claim, it really is dependent on that. I would just like to add that the Singapore government took an extremely pragmatic approach, which is, guys, stay calm, sit back, go back to your corners, we're not fighting anymore, and let it all settle down before you try and pursue what is right and wrong. And so then the national court processes will take. So it's really pragmatism that is the rule of the day in Singapore, and I think it's been great, because
it hasn't set off a panic attack amongst business owners, amongst people who have the upper hand in legal relationships, or the ones who are suffering from the current climate.
Andika, back to you.
Yeah, if I can just add to that, especially with regard to legal advice and the integrity in legal advice, one experience of the moratorium that the Sri Lankan government has introduced is the postponement of repayment for, I think now it's going up to about 6 months, plus in respect of banks not enforcing mortgage rights and all that. But the banks have now in a situation where people are seeking a moratorium for economic and financial trouble they had before COVID. So I would like to ask Krishna whether the moratorium or any not to use it as an escape clause, but can you use the pandemic period to get out of problems that have been creeping up on it, notwithstanding the pandemic, like that?
Yeah, I mean, that's a great question for a couple of the cases that we have. And really, in one particular case, it's a construction matter, and an expert witness has to come in. But essentially, it is it's to see if there, whether there had already been a pre-existing condition of a prospective breach, and the overlaying of COVID cannot be a convenient way of avoiding what the obligations would have been. So to put it plainly, I think that's the approach that the courts are going to take. And even if you look at the very basic principles of the components of frustration, we're going to look at whether there has been a genuine hindrance, and certainly, as Kubera mentioned earlier, it's not a case of being highly inconvenienced or having made a bad bargain and then trying to look at this scenario as coming up. There were certain cutoff dates before contracts were made, and it was quite well crafted, because you almost had a month after everyone kind of knew we were in a pretty serious situation. And if contracts were drafted after that period, then it's going to be tough for you to argue, even if post that date, which was I think end of February, if you had drafted contracts, that for you to then state that, oh look, I never foresaw that the COVID-19 crisis would have extended beyond 4, 5, 6 months. So very pragmatic approach once again, and I think it really depends. For some industries, it's quite easy to tell whether it is an overhang from a pre-existing negative situation that had already afflicted a particular party, and then them trying to cunningly rely on it during this moratorium period, or whether you actually have in certain industries, and I dare say real estate is one of them, and even in the construction industry, where it's harder to actually pinpoint the period as to when if you like, there was a tipping point in terms of whether it's the real estate value, or whether it's in terms of the ability to assess resources to complete projects, etc. But one thing should be kept in mind is the need to mitigate all of these circumstances to the extent possible, because there is usually a carve-out, which is the essential services and essential products which need to be provided. So just because it's going to require you to take an exceedingly different and a hard route to have some items delivered doesn't necessarily mean, particularly if it's an essential item, that you are forgiven your obligation. So I think common sense will prevail, frankly, because the courts are going to be inundated with these matters. But as you, Chandika, as you mentioned, if integrity prevails, which is practitioners like ourselves to pretty much make an assessment for and on behalf of the client that, look, let's not try your luck on this, because the reality is, putting aside pandemic, if it was a naturally occurring event, would you have been able to get out of it in the first place? So Thank you.
Running on mute here. My apologies. I was running on mute. Thanks for that, Krishna. Technology, I don't need to tell you how wonderful it is. So it's been giving me a bit of trouble the last couple of weeks, actually, come to think about it. So there is actually one more question that's also directly at you. What are some of the fintech or technology related issues that you see arising from COVID-19, and how is the Singapore government dealing with it? For us, I think fintech is something that's still very, very new. So the learnings, from your end would, I think, really be of value to us.
Yeah, I thank you, Rai. I mean, it's an interesting question yet again. I'm very impressed with our audience today. In fact, there was a commentary in the Straits Times today about how COVID has been great for the fintech industry and particularly for the cryptocurrency sector, because now you have got countries that are exercising turfism around their central bank policies in terms of their own currency. There has been, if you like, an overextension and over-reliance on the US dollar and its dominance. And so for them to decouple from the US dollar, it means that they would have to pretty much roll out their own digital currency, their own centrally backed digital currency. So I see that as a significant way forward, because when you talk about digital assets, digital currencies, and you talk about blockchain and DLT related matters, distributed ledger technology matters, it generally goes over most people's heads. But one good publicity event has been COVID for this sector, and it's really bringing to the forefront what we had almost conveniently chosen to forget and assume that it's just one very small sector. But Singapore is at the forefront, and if you think about Singapore being at the forefront, then I would say China is light years ahead. And if you go to a place like China, you can go to a wet market, and they are so digitally connected. The transactions are done over QR codes. There's just absolutely no currency, and it really brings to the fore the subtleties around the trade war between the US and China, because it goes beyond the posturing that Trump obviously would want as the boogeyman for his election year, because he can't rely on a very good economy. But if you think deeper, it's really about the greater significance of who would assume the superpower role, and really at the end of it, it's about which country is so digitally connected and allows for all of its small micro business ecosystems to thrive. So putting Singapore aside, I think China is light years ahead against the rest of the world. And let's not discount what Sri Lanka has as well, because it has a very disproportionately large amount of very intelligent people, and so it's actually, it can work. It works to Sri Lanka's advantage because it is intellectual capital, and when you are looking at the digital ecosystems, it's the intellectual capital that has a multiplier effect in terms of weighting, and I think that's something which should be encouraged, by. And in that instance, taking a leaf out of the Singapore book would be helpful and useful, because it gives Sri Lanka the opportunity to kind of leapfrog, if you like, a couple of genres of technology and go straight up to being digitally connected, in my opinion.
Thanks again, Krishna. Interesting insights, and as you said, interesting questions coming from our audience this evening as well. There's another one. Okay, so I'm just going to throw this.
Sorry, right.
Yeah,
Chandra,
can you
add to Krishna, because as he said about Sri Lanka, now Sri Lanka also technologically, during this COVID situation, we have got, from the fact that the vegetables are coming around in carts, which is like the other side of development of technology, to Pick Me and Uber now doing contactless doorstep delivery, or such things I find that Sri Lankans, although maybe the technological infrastructure is not there, the consumer in Sri Lanka and the businesses in Sri Lanka pretty adaptable to technology, because now the way PickMe and Uber has spread, it's not only the fact that Uber or PickMe they are doing it, it's just that now even the small time batkades or the rice the small time restaurants down Gold Road or down any road in Sri Lanka is basically on one of these service providers. Plus, there is a lot of stay-at-home, small industries coming up, from making cupcakes to I saw one called Mad Mousse, which specializes in chocolate mousse. So those are very specialist ideas, but that has become possible because of technology. So, and for some luck, we have our Electronic Transactions Act of 2006, which I think is quite advanced to the extent that even that act has been drafted in a way that it adapts to anything. It can basically adapt from, although it was in 2006, provisions of that act can be adapted to Instagram or even TikTok if you want, because the way it has been structured is a very wide way of wide interpretations have been given to what is electronic, what is technology. So I see one of the fields that has really developed this technology in respect of or because of this adversity. I think there are very few fields which have really succeeded, but technology and service provided through technology is one of the fields that Sri Lanka has really caught on and adapted.
Absolutely. I think Sri Lankans are well poised, and it really requires the conviction of a few committed and convicted personalities, because even in the digital sphere, some of the leading OTC traders in some of the big cryptocurrencies emanate from Sri Lanka. So it's there, it's ripe for the taking, but it's a question of opening it up and recognizing the talent that remains there, is there.
So Chandaka,
I like how you go ahead.
Add something to what you said, Chandaka and Krishna. I think we are at the not at the threshold stage. I think we have advanced where all the service providers are also now testing 5G in Sri Lanka. So 5G technology to be introduced. So we have advanced in that sphere, I think, to add something to what Chandaka said. So I think that is unstoppable. Everything will be in future will be starting from the school kids, from the education to sale of goods, service providing of services. I think even this present webinar that we are doing, I think is an example of classic example of to what extent technology has gone to. Nice to have you from Singapore with us. I think that will be the future and the way forward.
Thank you. It was a privilege and an honor, especially being, having been born in Sri Lanka. It's my greatest, wish and hope that it flourishes as it once did.
Thank you, Krishna. That's a wonderful sentiment. And I also have to say I'm thrilled at how you said that there's a disproportionate amount of intelligence in Sri Lanka.
Well, I'm
brilliantly put.
I'm judging by the host certainly, and the panelists. Almost without exception, everyone's of that standard.
Very well put. So we have a question that's kind of on the flip side of what we were talking about right now. Dilshani asks, how can the rights of digital users, which have been impacted due to the accelerated use of technology due to COVID in Sri Lanka, be protected, especially in the context of the unavailability of a Data Protection Act in Sri Lanka? So that I think I'll have to sort of ask a combined answer, because Krishna is not going to be able to answer in terms of the Data Protection Act, but certainly to all of you out there, what's your thoughts on that?
And perhaps to give the rest of the panelists some time to collect their thoughts, I'll just quickly reply from a Singapore perspective. The reality is the rights are going to be, we are going to struggle. I mean, there is there's a perceived suspicion on whether it is a tracker for where our movements are, whether it is it's the input of certain data when you visit certain stores and shops, right? It is questionable, what level of monitoring there is and when it actually stops, because as we sleep, and if you allow for updates to happen on our phones, a lot of things can be updated and can be imposed by certain jurisdictions. So that's just my thoughts generally, not necessarily Singapore related, but generally.
Yeah, Rai, if I can join in from there, one of our biggest problems is the lack of or an absence of privacy law in Sri Lanka, digitally or otherwise. But it has become a huge problem especially, I think it was a problem before COVID. COVID is just, it's a manifestation of this problem that has been there, especially even if you look at move ourselves away from corporate and business and even on a personal basis, how the social media has been misused by people for so many reasons, for personal reasons, for sexual reasons or whatever. There is a dire need in Sri Lanka for not digital privacy, but a privacy law per se. And in the absence of such a law, all the authorities, including whoever the service providers, are running around trying to find ways out of, or trying to find and peg whatever that is happening to an existing law. Certain instances where the law has been given a very expansive definition, certain things it's easy, and I personally believe that especially the digital and the IT unit of the police is far ahead on how to pin things on something that the law actually would not allow. But the absence of a privacy law in Sri Lanka was there, and the requirement was there before COVID, and that is just manifesting itself now. And it is, I think there is a draft bill that is somewhere hanging around somewhere, I don't know, but it was supposed to go into Parliament. So hopefully with the new Parliament they will think of getting that into operation, because it's getting not only as far as business or commercial sense, but even on the personal situation, the privacy problem is going to be one of the biggest problems that will be faced. One other thing is, as a lawyer, I'm saying that the Sri Lankan judicial system is nowhere ready enough if these sort of issues start coming out into litigation.
To add something to that, can I add something to that, Rai, to what Chandrika said? I think there is a data protection.
Please do go ahead. Please do go ahead, sir.
Chandrika said there is a data protection law that is in the form of a bill which needs to be placed in Parliament. I think that the bill was drafted and finalized somewhere in October by a committee headed by Mr. Jayantha Fernando of the ICTA, Information Communication Technology Agency of Sri Lanka. So I think very soon that there will be a law. I think that the drafting committee of that data protection law, or the act which will come into place after with the placing of the signature of the speaker, have considered, taken into account international best practices, such as the OECD privacy guidelines, then APC privacy frameworks, things like that, international best practices. I think that's a very comprehensive law. I have seen the bill. So it's a matter of time, I think, with the COVID-19 situation, the pandemic. So that has delayed the data protection law. So you can find the bill if one wants to, it's available in the net. I think the bill you can, if one is interested in finding what this law is all about, it's available in the net. So one could access the Parliament website and access the proposed law. Thank you. Over to you, Raj.
Thank you, sir, and thanks for that bit of information. I'm sure that it will be very well received by our participants as well as the wider audience, because that's something that has been of great concern and something that's come up continuously on many of our online discussions and many of our forums. So that's a piece of information that will definitely be very well received, and I will also share it through our networks as much as possible. So then there's another question. Again, I'm just putting this out to the panel, and I'll invite anyone or everyone to share their thoughts on it. The legal requirement that directors should act uberrima fide towards their respective companies or organizations becomes impossible or difficult in a pandemic context. How could the concept of integrity be observed, especially when it comes to honoring contractual obligations and repayments, etc.? I know each of you touched on this from sort of a legal perspective, but moving a little bit out of the actual confines of the law, what are your thoughts, or what can you share? What advice can you share with the professional community on this?
Let me take a first try at it, and I'll let Quera and Krishna and Chandika weigh in. I think for directors to act uberrima fide or bona fide or in the utmost good faith it's a given. The law provides for it, and the fiduciary duties of directors are very stringently stipulated even in our company's law. But in these conditions that we are sort of facing currently, where cash preservation becomes critical and key to all organizations, and there are moratoriums given by governments even on debt repayments, etc. For companies to sort of pay out becomes obviously a challenge. And given that, I think the start of this conversation and this session, Chandika basically set out how important it is to act with integrity and do what is right, and that's what then befalls the directors, and that's what the directors then get tasked with, acting in the best interest of the organization, and that would also and the third parties that the company then owes money to as well. But in the first instance, they would have to look at what's right for the organization and their people. So then cash preservation, retention of jobs, ensuring that their employees are being paid and they have the ability to sustain their livelihoods, see them through this COVID situation where they are able to feed their families and take care of themselves, also becomes a responsibility that then befalls management and directors. So it's a huge responsibility, I think, in these conditions. I don't think it's to be taken lightly, and I think most organizations who do the right thing and who ensure that they run their organizations in the right manner, who act with integrity, would do what's best, that they would cash preserve, they would pay out as much as possible, but they would also use what's there in the business for business continuity and for the preservation of jobs and employment. So it's a difficult balance between what's right and sustaining and business continuity. So it's a very difficult balance in these current conditions, I think.
Yeah. Can I just chip in because this requirement of acting uberrima fide, I think, arises out of the age-old duty of directors to act in a fiduciary capacity towards the company. So the fiduciary capacity towards the company was that directors should always act to the best interest of the company. But although the law says that you have to act in or act uberrima fide towards the company, that fiduciary duty towards the company, that was the historical genesis of this, has now been expanded to the extent that fiduciary duty now directors owe that fiduciary duty even towards the latest expansion is even towards creditors. So it has been expanded from starting from the company to the shareholders to the employees and now it has been expanded to the creditors. So as Rajita says, it's a very fine line, it's a balancing act, but acting in uberrima fide, and there is also this concept that a company can't be just thinking of itself in a society, when like we can't as persons, if we can't always only think of ourselves but now have responsibilities towards others in society. The same concept has not been used for, and that is why this social responsibility, CSR projects and all these have expanded, because the concept is now changing from merely trying to satisfy your shareholders. Of course, these are very, very utopian kind of principles that are being, but there are companies which do follow it. So even if your primary legal obligation is towards your respective companies, if you don't act with integrity with your with your partners, say for example, if you to protect the company, you have to act against your let's say your service providers, your contractual partners, your buyers or your logistic providers, that going down that line will not give you a long term, will not give you anything in the long term, because the minute you break your contract today on the basis that you have to protect yourself, that guy is never going to come back to you and you will never be able to go back to that guy. So it's a very, very fine line, but I think that duty towards the company and your shareholders has to be balanced with your overall duty towards your other stakeholders, including your partners in the business, partners in the sense that your contractual contract parties with whom you have contracts. Because you won't be able, if you don't act with honesty with everybody, you cannot continue in business. That's what I feel. And people who come to us after everything is over, they come to the lawyers after the everything as well. If some of these parties have acted with some integrity or honesty at the commencement of a dispute, most of this litigation will not happen. So that balance has to be but I think this question comes with what Krishna said about the legal integrity of us as professional lawyers, because merely because you have a legal duty towards your company, I believe does not mean that you can just go and breach every other contract down the run. And it is for us to advise clients that is not the way to go, and it's a basic balancing act that the companies will, because these are extraordinary situations, and I don't think there will be legal solutions for all these problems.
Krishna, is there anything for you would like to add, or can I chip in now? Maybe after you. Hello. Krishna, I think your mic is on mute. I think to add some. Is it Krishna? Do you like to?
I was just going to add that thank you, Kuvera. That there's going to be a judge, and the judge would be, quite frankly, the shareholders or the employees, because come 12 months on or 24 months on, when everything dies down, they will be the judge of how how management has operated and how board has operated, and I think it's actually a great time for organizations to recalibrate and look at how they operate as a business. Even as a firm, we've had to constitute a committee to look into the well-being of our employees, because these are trying times, and so we just have to operate differently. And I think the reality is, it's easy to set a legacy which is positive from this event, and that will be the ultimate test, I think, for quite a few corporations. Sorry, Kuvera, please.
That's fine. I think to add something more to what Chandra said, I think since the law has now been extended with regard to the 5 different duties of directors to even to creditors, I mean, in the context of business integrity in the face of adversity, I think when it comes to payments, or maybe for sale of goods or providing of services, or whatever industry, maybe in the construction industry, I think it's best that, rather than seek a discharge in the current context, I think it's best that you renegotiate contracts, and maybe also you seek extensions with regard to performance. So in that context, because the governments, I think, are very keen to ensure that continuity of business and their respective economies won't suffer as a result of in face of adversity. So in that context, I think directors also has a responsibility while looking after its employees, shareholders. Also, there is a social responsibility that to ensure that the continuity of business is there, and also the economic, there is no economic fall down. So in that aspect, I think it's very important. Thank you.
Thanks very much again, Sri Soiza, and of course the rest of our panelists for all those wonderful insights. We do have one more open question. Now, I am a lay person. I'm not anywhere close in legality, so I'm not even sure if I can pronounce this right. So my apologies if I don't. We are being asked to, or you are being asked rather, to please touch on the impact and relevance of the dictum lex non cogit ad impossibilia in the context of today's topic. Now over to you, gentlemen. I hope I said that correct. If I didn't, my apologies. Gentleman and lady. Rajita, maybe you'd like to start on that?
Thanks for putting me in the hot seat. I'm going to actually
I think you're
the practicing counsel.
Hot seat.
I saw the question, but I'm not qualified to answer it, so I'm not going to even try to mislead the audience.
I think Kuera touched on this, right, in your presentation, Kuera? On this impossible that the law doesn't force somebody to do what is impossible.
What is impossible?
But if you can't perform, you can't perform. It's as simple as that. And if you have cogent evidence to show that you can't perform, then the law excuses you from performance at that.
But Chandaka, it has to be on genuine. I think it has to be on genuine reason.
Yes.
Mere inconvenience or difficulties would not pave the way for you to meet that maxim, have the benefit of that maxim. I think all these case laws and the current laws over a period of time has examined this principle, and there has to be genuine reasons for you to have the benefit of that maxim. Say that it has become impossible. So it's a case by case matter, and the circumstances of each case will have to be considered carefully with regard to that maxim. Thank you, Rai.
Thank you, everybody. Again, sorry, I actually dropped off the connection for a few seconds. So yes, please go ahead. I dropped off for a few seconds, so I have no idea what just happened.
Okay. I was just about to tell you that although we are 5 lawyers here, you can even, or 4 lawyers here, we will never ever pronounce that thing because I can't. I have never been able to do this. And don't ask us ever to pronounce Latin dictum. I think other than Krishna, I can't personally.
4 of us will pronounce it in 4 different ways, I believe.
And back to my point of the unproportionately high intellect representation, I think Rai did a better job than any one of us.
So thank you everybody. Any sort of maybe a 1-minute round of closing statements or closing thoughts that you'd like to leave with our viewers today before I do our formal closing?
Who'll start?
Chandaka, maybe we can start with you.
Like I said, I actually something that I was supposed to mention at one point of time with regard to the obligations of directors in especially situations like that where the company solvency is at issue, and also where there's a serious loss of capital which is happening in most of the companies at the moment because of the pandemic, but actually the reason is not applicable. It's just that if the company cannot pay its debts as they come due, which technically you're insolvent, and also if there's a serious loss of capital, there is an obligation on the part of the directors of a company under the Companies Act to immediately proceed to make an application to court for winding up, because you would not want third-party stakeholders to expose themselves to a company which at a particular point of time cannot meet their legal obligations. So in these situations, or because of the pandemic, the situation or where it has the serious loss of capital and insolvency has increased. So there is an obligation, and especially if you are advising directors, there is an obligation to do that, because if they don't do that and you can't justify it subsequently, you will be exposed for personal liability. However, it's not only winding up, there are other methods of resolving disputes, like you can enter into an arrangement or a compromise, or there are other methods of like equivalent to what we call Chapter 11 situation that says those things can be used. So we have to be aware of those matters. It's not a case of that companies need to necessarily destroy themselves, but find viable alternatives. Thank you, Rai.
Thank you very much, sir. Mr. D'Souza, if I can pass on to you.
I think the recent pandemic, COVID-19, has caused disturbances in the commercial world. I think Rajitha would probably agree with me. I have some statistics where it says, according to Bangladesh Garment Manufacturers and Exporters Association, international buyers have either cancelled or suspended $3.16 billion worth of shipments involving 1,100 factories, affecting 2.26 million workers in 2020. So in that, even the pharmaceutical industry, because 70% of the raw materials come from China, 1/3 comes from Hubei, where the the virus outbreak originated. So in that context, I think the entire world has been affected. So there is a responsibility. What I want to reiterate and stress upon is that when it comes to performance of contracts, or when a party, in the light of performance, if you're seeking a discharge from your performance and your obligations with regard to payment or either performance, there is a responsibility. I think in that context, I want to reiterate the fact that don't try to discharge all the time. Don't try to rely on a force majeure or frustration. Try to renegotiate your contracts and maybe seek extensions. Now, Chandaka, I think, quite rightly mentioned, though the government of Sri Lanka offered moratoriums with regard to certain industries such as tourism and agriculture when it comes to repayment of their credit. I think that scheme there are complaints that these schemes have not been quite rightly been implemented. So in that context, there is a responsibility on all of us to ensure that we face this pandemic situation and we progress and ensure that the least damage is caused to our economies. So that's the message that I want to convey to all to the entire audience. Thank you very much.
Thank you, sir. Rajitha, may I pass over to you, and we'll close with Krishna's comments.
Yeah, thank you, Rai, and agree with everything that's been said by all the panelists, and Chandaka and Kuera especially, and of course Krishna. Just in closing, just not sort of emphasize on the importance of lawyers or legal counsel, but these conditions are sort of unpredicted, unforeseen, and it's not something that any one of us were ever equipped to deal with. I think for all corporates, for all individuals, this is the time to rely on your external advisors and listen to them, whether they be financial advisors or legal advisors, your in-house counsel or corporate lawyers, because risk mitigation is key in these situations, whether you're trying to rely on certain contractual provisions to exit or stay in or extend your obligations and ensure that your economies and your organizations still run. But it's really critical, I think, in these conditions to ensure that you're listening to your advisors and not making emotional decisions, but making rational decisions as companies and corporates. So, and I would think that legal advice is critical at this point in time. And I would advise corporates and individuals to ensure that you are relying on your advisors at this point in time to ensure that your businesses and yourselves are protected.
Thank you. Very pertinent point there, I think, and something that will be well received again. Krishna, over to you.
Thank you all. I think that there's nothing much else to add, but if I could, on a philosophical note, just add that it has been painful the last few months, and by all accounts, there's going to be a lot more pain ahead. But I like to think that it's been a great opportunity for us to recalibrate in many ways. I mean, I'm sure all of us personally have benefited in some way or form, putting aside the challenges which initially came upon all of us. I just feel it's a great opportunity to reset many things as a corporation, as an organization, as families, as a country, things which we would not have had done before. It's a great impetus. I reiterate, the digital narrative is something which has presented itself for Sri Lanka. So if I have a wish for Sri Lanka, certainly it would be that it adopts that digital narrative, and that before long I'll be calling Quagmire President Quagmire from a bar association standpoint, that is.
Hopefully. Thank you.
Thank you very much, everyone.
Thank you very much.
Thank you, Bri. It was a fantastic.
Thank you. So to each of our viewers here on Zoom, of course, as well as on FB Live, to each of our panelists for the time that you've taken, thank you so much for your invaluable insights. Of course, to our viewers, do join us again next week when we'll be taking a deep dive into the digitization conversation that we just touched on today, and taking a look at what organizations have and can do in terms of harnessing the digital space opportunities and DLT. Details, as always, via the AmCham Bulletin, the WhatsApp broadcast, as well as the Daily FT. Don't forget, this session goes up on our YouTube channel, AmCham Sri Lanka, shortly. And in case you've missed past parts of this or even any of our previous sessions, you can catch up on those too. Reminding you, as always, please do watch, like, share, and of course, give us some love by subscribing to our YouTube channel, because it helps finance these resources so that we can continue to bring you these resources FOC. Once again, thank you to each and every one of you. Until next week, it's your friendly reminder from the AmCham team, as always, to stay safe, stay healthy, and of course, Aiboan to every single one of you, our panelists, as well.
Thank you.